revolving door. And that was chapter 10, conflicts, issues for government and judges. And we went through that chapter, and that's the last chapter on conflict. Then the next one, chapter 11, which we're going to do some of today, talks about our duties to outside entities. Primarily in chapter 11, our obligations as officers of the court. And we've seen this moving through the decisions in our discussions. We've talked a little bit about canvas courts of tribunal. We know that we're officers of the court. We even talked about it as an underlying issue when we have 1.6, confidentiality. Certainly confidentiality means that we preserve client confidences. And we saw how broad that duty was. It lasts even after the attorney-client relationship has been terminated. And so it's very important. But there are exceptions. And we're going to see today, it may come a time where we have to reveal a confidence to keep from presenting perjured testimony or false testimony. We see a case a little bit later on, Nix versus Whiteside, that says there is no constitutional right of a criminal defendant to present perjured testimony. Now, you defend your criminal client vigorously. You make the prosecution prove each and every element of their case beyond a reasonable doubt. You may even advance a defense that you don't believe in if there is a good faith basis for advancing that defense. But you cannot present perjured testimony. So we'll see some of that today. Now, before we even get there, we, in our last chapter, was looking at these duties that government attorneys have. And we focused primarily on the four rules up on the board. 1.11a really talks about the conflict where you have a former government lawyer moving to private practice. And we talked about how formal representation is a part of that analysis. 1.9c, you know that we can't use information from the previous representation in order to disadvantage and detriment of that former client. So we know that. We're subject to that. And then we shall not represent a client in connection with a matter. We have to figure that out, in which that lawyer participated personally and substantially as a public officer. So when he was a government officer, participated in this matter, we have to define what matter is. That could be a proceeding, that could be research, it could be any number of things. Personally participated substantially as a public officer. We noted that this rule is designed to allow movement between government to private and private to government. We don't want it to be so insurmountable that we undermine the fluidity of the legal profession. We don't want to impact clients' ability to have the attorney of their choice. So we talked about that. And then we said, if we find that the person participated personally and substantially. So this is going to be fact specific. Maybe you were a government lawyer and you reviewed a couple of research memos and offered your opinion in one paragraph in an email. And then you are moved from government to private practice. And the matter may be related, but we want you to be personally and substantially involved. And if you have not been, then you can work on that issue. Now, if you have been personally and substantially, you were responsible for this case as a government officer. You saw it through from research to pleadings to proposing legislation and all of that. You are personally and substantially involved in that matter and cannot do anything in the private sector unless the government gives informed consent. So 1.11a really defines the conflict. It tells us if you are a government officer, you move from private practice, you may have a conflict because of the formal representation. We want you to be careful. 1.9c, which talks about using whatever you have in the prior representation against that client, unless the government gives informed consent. Now, the government may not give informed consent, and then we move up here. This is a theory of imputation. We're still talking about that former government lawyer, moving into private practice, but that lawyer has a conflict. Conflict moves through the firm. And so we say, okay, that is a conflict that moves through the firm, but that former lawyer is precluded from handling that matter. Okay, we just make sure that that lawyer does not become involved in this new matter. Timely screen, written notice to the appropriate governmental agency. We don't have to seek consent from the government agency as a prerequisite to taking on this conflicting work. And there's no detailed information about screening like we talked about earlier with imputation. That's on page 445. Then we talked about confidential governmental information. That is non-public information that is derived from your former participation as a government official. If a former government lawyer has actually learned, look at comment 8, information about a person that was obtained under government authority, and that could be used to the material disadvantage of that person in a new representation, the former government employee cannot take on that work. And that really cannot be cured by consent, because you'd actually be asking the government to allow you to use this special type of information against someone in the current representation, and that would be certainly unethical. The disqualified lawyer, again, can be timely screened from any participation in the matter and no fee. So screening is permitted here as well. And then in this last category we talked about, that is where you have a current government lawyer who has moved from private practice. And we talk about former client conflicts. So notice this, the current government lawyer is subject to 1.7 current conflicts and former conflicts, and shall not participate in a matter in which the lawyer participated personally and substantially, same thing, while in private practice. So we looked at all of those as scenarios when the lawyer moves from public to private and private to public. Now, we also looked at judges, looked at those ethical canons and discussed those. And I think the last thing that we had to do was, did we do the judge's former professor? On page 466? Probably not. We did, okay. But before that we did the DA, problem 10-1, and we looked at that and just went through the two cases substantially related, and we came to the conclusion that there is a substantial risk that a lawyer representing a child injured in an accident would have learned facts that would materially advance the current prosecution. You know, things like brain damage, mental illness, history of child abuse. So we noted there that the test is not actually what the lawyer knew, but whether a lawyer might reasonably come into this type of confidential information that could be adversely used to the former client. That would be brick in this subsequent representation, this prosecution. And there is evidence that could be used to discredit Brick's offense. And we noted that in the real case, the prosecutor was disqualified. That was problem 10-1 that we did. So, 10-1 was on page 449. So now we're doing 466, the judge's former professor. Now this actually happened, this you may not know, this is former President Clinton and a federal judge in Arkansas. So, you know what ultimately happened, but then the question in this case is whether or not the judge should be disqualified. And so we looked at, in doing this problem, we looked at the judicial canons, starting on page 450. So you need independence and impartiality, competence and diligence, should minimize any conflicts and all of those things. Now, each of those canons have individual rules under them. And so the individual rule that we're looking at in connection with the judge and former professor is Rule 2.11. Now that's in the Code of Judicial Ethics. That's towards the back of your book. It talks about disqualification. So we're going to use this rule to look at and the question is, should this judge be disqualified? And you get this: a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned. And then we have these different circumstances set out in the rule. And you have that on the top of page 467. Prohibits a judge from allowing family, social, political, financial, or other interests or relationships to influence the judge's judicial conduct. So that's 2.4. And then you also see Rule 2.9. I'll put family ties here. Disinterested expert here. And 2.1 just talks about this part. So, has Judge Lynch violated either of these rules? If so, should you object on behalf of your client to Mr. Lynch's involvement? Review the relevant rules before you answer this question. So you have the facts on page 466. There's some prior relationship with this judge. The major thing is that Judge Lynch's husband participates in ruling on motions and discusses that with his judge. There are rumors that Mr. Lynch helps his wife to evaluate and decide cases before her. So, should the judge recuse herself? Should we advance this motion? What do we do here? If the plaintiff's lawyer does not file such a motion, should we do so? What about this? Is this ground for a refusal? Or better yet, if you were the judge and, the attorney in this case, would you try to advance a motion for recusal, or would you leave it alone? What would you do? These rules are way in the back in the canons. So 2.4 deals with external influences. on judicial conduct. And 2.9 talks about the court being able to engage disinterested experts. So what do we do here? Would you file a motion to recuse this judge? Yeah, Ms. Moore, go ahead.
Yes, because under municipal litigation, Rule 211, it says that the judge shall disqualify himself or herself in any proceeding in which impartiality might be reasonably questioned.
Okay, so the judge would have to do that, right?
Right.
Okay, so that's interesting. So this, you notice in the readings, it comes after this whole discussion about Supreme Court justices not being subject to the code of ethics. And sometimes there are cases, like the most notable was the case where the court was going to rule on an environmental protection agency or something, and Justice Scalia had gone on a hunting trip with then Secretary of Defense, I think Cheney, Vice President Cheney, and then I think that he was involved in this EPA commission, and the question was that a conflict of interest? Does that undermine impartiality? And the Supreme Court justices have always argued that this is a court of last resort, and we don't have to recuse ourselves, unlike other federal judges or state judges or anything. So this rule is sort of drafted so that a judge will see this disqualification, and the judge will disqualify himself or herself. So that's sort of like the judge taking initiative. Now, if the judge doesn't do it, you have to do it. Let's say that the judge doesn't do it. She didn't in this case. Now what? Should you move to recuse the judge? I think certainly if we read the rule the way it is, there is a ground to question this judge's impartiality. That just even the rumors that are circulating around in the legal community, that her husband may help with motions, that there is this prior relationship, all of these things. So nothing much happened in this case. In real life, the judge did not recuse herself and went on to rule on President Clinton's misconduct. Remember, he took the deposition and he was being questioned, and he said it all depends on what is, and that was sort of a misrepresentation. Then his lawyer has to report that to the federal judge. This federal judge was Susan Wright Weber, and then she moved on that, and then that's what really ultimately led to President Clinton's disbarment. I think he's since been reinstated, but that is what caused him to be disbarred. So in this case, I think the judge would have to do it, and then you would have to make a strategic decision about whether or not you move to recuse. There are upsides and downsides, and on these facts, there are facts that sort of look at impartiality, but the second question is, should you file it just because you can? And in this case, in real life, the judge stayed on the case and ultimately ruled on Clinton's misconduct. Now, the only other thing in this chapter is conflict rules for former judge, law clerks, arbitrators. So a lawyer cannot represent in a matter in which she participated personally and substantially as a judge. So that's a judge moving to private practice can't do that in terms of representation. And then finally, there is room for you. Look at page 469. As a law clerk, you can negotiate for employment with full disclosure. Because notice, we recognize that you'll probably be moving from that 1-year clerkship or 2-year clerkship into private employment. So your law clerk on the 6th Circuit, open disclosure to your judge and anyone else that you are negotiating to go with the public defender or a firm here in town, Wyatt, Aaron, and Combs. That's fine. You see that on the top of page 469. A lawyer serving as a law clerk to a judge or other adjudicative officer may negotiate for employment. So that's all of the conflicts. So we've done current conflicts, former conflicts, special conflicts, and then conflicts when a government lawyer moves to private practice and a former lawyer moves to private practice and a government lawyer moves from private practice. The revolving door. And now we're looking at another form of conflict, because it may form a conflict with our client because of our overarching duty as officers of the court. So if you look at chapter 11 on 471, lawyers' duties to the courts. So notice, over and over again, the theme in this course has been that we represent a client, we have undivided loyalty, we have confidentiality concerns under 1.6. We have all of those things, but we have to balance those with the rules of professional responsibility, the other law, and then external obligations that we have. And our most primary one is as officer of the court. So, what about this? This is interesting. This chapter starts off with the traditional discussion about what type of lawyer are we? Are we hired guns or are we officers of the court? In other words, this sets up this tension between higher principled lawyering and hired gun. In other words, advocating for a particular viewpoint at all costs. You see that on page 473. So there's this discussion of, client-centered lawyers. In other words, we advance the client's claims at all costs, even if that means some compromises on our higher duty as officer of the court. So you see this discussion on page 474. Stephen Gillis, can a lawyer be a bad person? And so I want you to sort of unpack these two hypothetical examples here. They're interesting. The first one is one designed to evoke sympathy to you as an attorney. We have first a man whose lifelong dream has been to open a fancy restaurant. He persuades a wealthy cousin to give him $50,000, but the man who wants to open the restaurant isn't totally sophisticated in business affairs, and the rich cousin who loans him the money is. As you can imagine, the restaurant takes off and is hot, and the man who has signed a note for the loan opens this restaurant. Food critics give it rave reviews. Then the cousin, who's the sophisticated one, comes in and demands payment of the loan, hoping to push his cousin out and take over the restaurant. The man goes to a lawyer, and notice this. So the whole issue is whether or not the lawyer can advance formal technical motions in order to protect the client and buy time. Maybe the client will be able to find the money from a bank. Maybe the restaurant will stay in existence long enough so that the receipts that are coming in will help him pay off this $50,000. So we're representing this client who has sort of been taken advantage of by the wealthy cousin. And we are making non-frivolous motions to buy time. Is that okay? So notice the type of motions that we're bringing. For example, one motion points out that the law requires process servers to be 18. The process server in this case was 17 years old and 11 months or something. But we make that motion just to keep them. Is that appropriate? So before you answer that, look at the other hypothetical on page 473. Same type of formal technical motions to buy time, but this scenario is constructed to contrast with our representation of the good client. Now we're representing a quote bad client. We represent a construction company. And so we're trying to use formal technical motion practice in order to force settlement of the case. We just keep it going. We know the other side doesn't have money, so we just dump all the documents on them. There'll be document production. Every motion that we can press, we will. You know, everything to this is the wrong type of margins in your pleadings, to time limitations, all of those things perfectly within the rules. And we're doing the same thing that we did for the good client. What about that? And so on the bottom of page 475, it says, question about being a good person. Do you expect to use such tactics? If your answer is yes, do you expect to have any moral qualms about doing so? You know, that's a question that gets at practice, the morality of practice, but more importantly, should we be really relativist when we talk about morality? In other words, when we're doing it for the good client, that's great, but when we're doing it for the bad client, we should feel cheesy about it. What about that? How and when should you use these formalistic techniques to advance your client's claim? And does it depend on who the client is? What about that? Can a good lawyer be a bad person? What about that? Talk, go ahead.
I think it's situationally dependent. In one case.
Situationally dependent. Tell us what you mean by that.
Well,
Because that you get that could be dangerous. So I want you to go ahead.
it can be dangerous, but morality itself is not a simple topic. There are many different moral theories. I mean, Kant, Plato, Aristotle. But for example, with the situation with the restaurant owner, he did get taken advantage of, and he is trying to pay back this loan, but he
Okay.
needs more time to do it. That's not,
See, I feel good about that one. That's okay.
because it's not necessarily like a sort of like, I guess, danger or extreme disadvantage to anybody else. But in the other situation, you're trying to force people who have been taken advantage of by your client, and you know they've been taken advantage of by your client to settle. It's the
But
most.
you represent the client in both instances. So how do you make those distinctions? Yeah. Go ahead. I mean, we can pick and choose our clients. There's some people we may not want to associate with, but in these hypotheticals, we've made the choice to represent, and that comes with some consequences. So we feel good about the restaurant hypo, but what about how do we understand and say that we are still representing a client that deserves representation, even if we have to do this? Are we still on the same moral ground that we are when we help the person who's been taken advantage of?
Honestly, to me, it boils
Yeah,
For example, if you were a subscriber to Kant's ethical principles, then you would be extremely immoral because in his view there is, for example, it's always morally wrong to lie.
Yeah.
But as we've seen from the rules of professional conduct, there are situations where you technically have to lie in order to preserve client confidentiality.
or not affirmatively undermine your client's position. Yeah, that's true. But see, this is what, so we're in the classroom, we can have these like conversations of the great philosophers and stuff, but when things are moving in real life and you have these two clients, how will you keep these two things moving, if in one instance you're being good and in the other instance you're being bad? It's just something that unifies those two approaches. But say you're a firm and you represent both clients. Yeah, go ahead.
I was just gonna say, I mean, how do you love it if you're championing your client's interest? So, and that's, I mean, what each one of us do.
Uh-huh.
At the end of the day, so, I mean, despite the fact that in the second instance, I mean, it may not be friendliest in the world.
Yeah.
You know, that's part of the job also.
Yeah, yeah, and that's what advocacy is. And so on some level, it's not good or bad, it's using these rules effectively. And notice how that leads to our discussion of Rule 3.1. Can someone tell me about 3.1? Investigation before, so notice this brings together Civ Pro, what you did in Civ Pro and now. So I guess this, what you talked about, the well-pleaded complaint, this is Rule 3.1, meritorious claims and contentions. So this is from our role as an advocate. What does 3.1 tell us? So it says something like this. Investigation before filing a complaint. That's on the bottom of page 475, and then it moves us over into meritorious claims and contentions. This is one of our duties to the court. And it sort of incorporates all of the things that we'll be doing in candor when we look at Rule 3.3. But notice this. Lawyers shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so. The most important thing in here is unless there is a basis in law and fact for doing so that it is not frivolous. So how do we know if something is frivolous or not? Yeah, go ahead.
Whether or not you think you can actually make a good faith argument to support whatever claim you're asserting.
Okay, that's good. So how do you know when that is? Which includes a good faith argument. So something that's not frivolous is you have a good faith argument for extension, modification, reversal of an existing law. And you have to be able to support that. Some basis in law, in fact, for advancing this claim that's not frivolous. It includes a good faith argument for extension, modification, or reversal of existing law. So that does not mean whether you'll win or lose or whether you'll be successful. Is can you advance this argument and can you support it? If you look at in determining the proper scope of advocacy, account must be taken of the law's ambiguities and potential for change. So the lawyer can advance inventive arguments or first-time novel arguments as long as there is a good faith basis in law and fact for doing so, not frivolous. That's comment 1. Now, look at Rule 3.1. It seems to make a distinction for a lawyer for a defendant in a criminal case. What's the difference there? Why are we emphasizing criminal cases in 3.1? A lawyer for a defendant in a criminal proceeding or the respondent in the proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. Why is that distinction in there? Because notice the rule tells us what is not doesn't give us a definition of what frivolous is, but if you look at comment 2, it says that discovery will help us as well. So you don't have to just wait and say, well, I need to really substantiate this. Comment 2 says the filing of an action or defense or similar action taken for a client is not frivolous, merely because the facts have not first been fully substantiated. So that takes into account that the lawyer will make arguments and that they will develop through discovery. Motion practice will begin to corroborate and substantiate our claims. That's going to become important when we look at the first problem here. So lawyers have to inform themselves about the facts of their clients' cases, applicable law, and then determine what type of good faith arguments can be made. So you're looking at the law goes against your client, and you say, oh, there's some things in the Sixth Circuit that are ambiguous. And maybe those gaps in the law is what will form our argument. And so we do some more research, and we say, oh, yeah, maybe we have a claim, and then we go through discovery. And then, oh, yeah, we're able to substantiate that. So it's not winning or losing. It is, can a good faith argument be made? After we familiarize ourselves with the facts, we do some research, we substantiate this through motion practice. The action is frivolous, however, if the lawyer is unable to make a good faith argument on the merits of the action taken, or to support the action taken by a good faith argument for extension, modification, or reversal of existing law. So if you can't come up with a good faith argument that's substantiated by something, that is going to be clear evidence of a frivolous action. You'll be open to discipline for that. Now, I think the criminal sentence in 3.1 is different, Because it's saying that so much is at stake at a criminal trial, that liberty interest, possibility of incarceration, Fifth Amendment, Sixth Amendment, that the criminal defense attorney is free to put the prosecution to their proof. You know, in any number of ways, so long as you're not offering perjured testimony. And so on these next pages, you have this notion that 3.1 also overlaps with Rule 11 in civil procedure. And starting on page 477, parties' legal theory must be warranted by existing law or by a non-frivolous argument. Same thing in 3.1. If you're making a good faith argument for modification, reversal, or extension of the law. And so we want some support for these theories that we are advancing. Notice at the bottom of page 477, there's no definitive answer about how to interpret 3.1 and Federal Rule of Civil Procedure 11. Most of these type of discussions have been fact-specific court decisions. So we can't really generalize it, but notice on page 478 to 479, there are some things that the attorney has to do in order to meet her obligation under Rule 3.1 and Rule 11. So you have to make sure that you analyze the facts to make sure that the suit has some grounding. You have to make sure that you're getting the correct facts. You have to make sure that there's some investigation and you understand the standard of any type of action or motion that you are trying to advance. And so the question often is, should the lawyer trust the client? Certainly, but there has to be some level of skepticism in terms of evaluating the claims that you're trying to advance on behalf of the client. On page 480, there's a comparison between Rule 3.1, where you'd be subject to disciplinary action if you violated the rule, and Rule 11, where the judge has the power to punish monetary sanction or non-monetary directives. And there's a safe harbor provision in Rule 11, but not 3.1. So even though you see in there, even though 3.1 doesn't have a safe harbor provision, it's common practice to say, well, if you withdraw this within an appropriate time, you're not going to be subject to discipline. That's on page 480. So having said all of that, you see on page 482 our first problem, Paula Jones. Problem 11.1. So the reason this problem is in the book is sort of high stakes. You're thinking this would be a garden variety sexual harassment case if the president was not involved. But the president is involved, and this was during the time he was governor of Arkansas. Paula Jones claims sexual harassment and assault. And so how would a reasonable lawyer go about checking out this story in order to comply with 3.1? And it says that the fact pattern is asking you to act as if nothing, you don't know anything else. There's no Monica Lewinsky trial. There's nothing like that. That will come later. And you're just evaluating these facts. And this is from the Federal Reporter, Eastern District of Arkansas, 1994. So what, if anything, do we need to do to corroborate Paula Jones's allegations before we sue the president? Look at comment 2 to Rule 3.1 and see if that gives you any help in terms of what you should be doing in terms of corroboration. So what this is illustrating is one way to determine if something is frivolous or not is you ask yourself this question as a lawyer: can it be corroborated? So if you look at 3.1 in Federal Rule of Civil Procedure 11, they're both saying we want something that's non-frivolous. They're both saying on some level we need some evidentiary support. So how would you go about doing this? And you shouldn't just be saying, well, this is the president, so I can't. So how would you go about approaching it? In answering this question, assume that a jury could infer from these facts and prove that the president committed the tort of sexual harassment. Also assume that the president is not constitutionally immune from being sued for unofficial acts. So how will we corroborate this? So one way to do that is to look at these facts, then figure out who we would talk to or what we would need to see in order to corroborate our client's claim. So how would you approach this? Is there some things that we should consider? What do the facts tell us? One thing, look at who we should talk to. Mr. Madden.
Well, the only other person besides Paul Jones and the governor at
Mhm.
the time, the facts mentioned is the bodyguard.
Mhm.
I would be hesitant to go straight to the bodyguard
Mhm.
and substantiate that. But you could look, there were other people at the registration desk or other hotel employees who may be more disinterested than the bodyguard would be, to see if they saw her in the room or going to the room or something like that.
That's right. Anything else? So we probably don't want to start with the bodyguard, but we can work around people who may have been there to try and find out. Ms. Harper?
Is it possible to try and get like security camera footage?
Yeah, but let's say it's 1994 though. We're not dead. It's sort of, yeah, there's security cameras, but they're not working properly. But that would, if it did, that would be good. Anything else though in terms of people, documents?
Oh, sorry.
Yeah.
She saw that piece of paper. That would be
Mm-hmm.
good.
Good. Yeah. Good.
There's claiming that they abolished this position, but it's not abolished. There's got to be some sort of paper trail of communication between these individuals higher up to show that, like, hey, we're going to blackball this person.
Yeah.
Because you didn't.
Yeah. That's good. That's good. But I think all of you are illustrating. It's not really clear what a reasonable lawyer would do to check out Jones's story, but those are several things that should be considered. Probably not the bodyguard. The bodyguard is close to the president, but we could work our way up to the bodyguard. And if we did have that discussion with the bodyguard, it would be based upon other things that we found, and then we say, is this true? Like the documents about the position, any other witnesses who could be, as Mr. Manley said, disinterested in quotation marks, any factual eyewitnesses. But it's not really clear how we would check this out, but the first thing we'd have to do is to analyze the claim that she wants to bring. And we note in the fact pattern that if we prove those, then we can establish that the president committed the tort of sexual harassment. We have our client's factual interpretation of what happened, her factual narrative, and all we need to do at this early stage is to corroborate that. And so comment 2 sort of gives us some help in doing that. And I think as long as we had a good faith basis for advancing this claim, it wouldn't be frivolous and we could move forward. Truth and falsity in litigation on page 483. Someone take me through rule 3.3. It's fairly candor towards the tribunal. This is explicit recognition of our duties as officers of the court. I mean, you have the chart on page 483, but so this rule does basically 3 things. It tells us that we shall not introduce a false statement of law to the tribunal. It tells us that as part of that duty, this is a separate section, we shall not fail to disclose adverse authority in a controlling jurisdiction. So we are in the Western District of Kentucky and we're litigating a securities case. An opposing counsel does not cite a case that goes squarely against us that everyone knows about. I guess some sloppy lawyering opposing counsel has not brought that to the court's attention. You have to bring that to the court's attention. And that's not so devastating. You will have known and thought about how to distinguish this anyway. But you must affirmatively disclose directly adverse authority in a controlling jurisdiction. That's 3.3A2. So it starts off 3.3A1 by saying you shall not knowingly make a false statement of fact or law to a tribunal or fail to correct it. Statement of material fact. So notice that's affirmatively you cannot present this false statement of law or fact. And if you know about it, you have to correct it. 3.3A2 says you cannot fail to disclose a adverse authority in a controlling jurisdiction. 3.3A3 says you cannot offer evidence that you know is false. You have to know that it's false. Now notice how that gives you a little bit of room as an attorney. Cannot knowingly present false information. Now, on some level that does not mean willful ignorance because knowledge can be inferred from the facts. But 3.3A says you cannot offer evidence that you know to be false. So what happens if you have a witness on the stand and everything's going fine, and then you realize, and the trial is still going on, you realize that your client has presented false testimony? What does this rule tell you? Because notice, you've offered that false testimony. In the form of your client. So what does 3.3 tell you have to do? Yeah, go ahead.
No, you have to correct it.
Correct, yeah, how do you go about doing that though? So, yeah, how would you go about doing that?
So, I guess you would have to, you have to affirmatively disclose, so, that's really kind of personal. But I guess that you'd have to like affirmatively address that you had done it, like, you can't just like sweep it under the rug.
Okay. So notice this. Shall not knowingly offer evidence that the lawyer knows to be false. And if we come to know of it, that we've offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. So what does that mean, reasonable remedial measures? Seems like we're always qualifying our duty. Yeah, what does reasonable remedial measures mean? So we shall not knowingly make a false statement. And I'll just put here, I'll just put must correct the false statement. So we can't actively do it, and if we make a mistake, we have to correct it. Shall not fail to disclose, just paraphrasing the rule, adverse authority in a controlling jurisdiction. Or offer evidence that the lawyer knows, has to know, and if the lawyer comes to know, the lawyer shall take reasonable remedial measures. So do we have a clue about what these reasonable remedial measures are in case we have inadvertently presented false testimony? Yeah.
So, I mean, it says like you should counsel your client to correct the record.
Yeah.
But, I mean, I'm just thinking, if you're gonna directly question your own client in a trial, can you just correct the record then?
Well, your client has to have input, so you're not gonna like turn on your client. The first step in the way the rule is done is, we have to tell the client, I'm an officer of the court, we can't present perjured testimony, you really should change this, I hope that you correct it. Client says no, then you say, well, now I have a duty to disclose, even though this may be 1.6. So the rule is sort of designed so that you'll sort of use your leverage on the client to correct. Look at comment 10, it sort of answers this. So comment 10 talks about these remedial measures. And so not a real direct answer, because these are fact specific. Look at comment 10, and it says this. Having offered material evidence in the belief that it's true, we subsequently come to know that the evidence is false. The lawyer must take reasonable remedial measures. So this is what I was talking about. In such situations, the advocate's proper course is to remonstrate with the client confidentially. Take the client aside, look, I know that you presented false testimony. I'm not turning against you, but I have a duty as an officer of the court that I have to balance with my advocacy role for you. And advise the client of the lawyer's duty of candor to the tribunal and seek the client's cooperation with respect to withdrawal or correction of the false statements or evidence. So we want the client to do that because on some level, if we have to go further, we will be turning against our client. So we want that united front where we say we made a mistake, the client is going to withdraw, my client is going to withdraw this testimony, we want to correct it. So notice how this runs through the rule of if we make the mistake, we certainly have to correct it. If we come to know of our client doing it, we want to tell our client we need to make this correction, and hopefully the client will do it, because you'll say, I'm balancing these two things. My higher calling on some level is as an officer of the court, and I'm not going to jeopardize my professional reputation or expose myself to discipline by offering perjured testimony, which I shall not do. So notice it goes further. If this fails, my persuasive argument to my client to correct this, if this failed, the advocate must take further remedial action. And maybe you withdraw and say, no, I'm not presenting that, but then the rule goes on. If withdrawal from the representation is not permitted, or will not undo the effect of the false evidence, the advocate must make such disclosure to the tribunal as reasonably necessary to remedy the situation. Now notice that limitation. That doesn't mean that you dump every confidential thing under 1.6. You do exactly what is necessary to remedy the situation. We want an appropriate correction. Notice this, even if doing so requires the lawyer to reveal information that otherwise would be protected under Rule 1.6. Revelation may be appropriate. And I say may because this is the second step after you try and convince your client. Revelation may be appropriate, notwithstanding 1.6. So this is a long-winded way of saying we don't want to correct that ourselves going against our client. We want our client to correct it on the record, and then we move forward from there. So that's A, 1, 2, and 3. What about letter B? So this is up to here, these are mistakes. But letter B deals with a situation where the lawyer knows engage in criminal fraudulent So up until this point, it's been fairly inadvertent, but look at this. A lawyer who represents a client in an adjudicative proceeding, and he knows or she knows that that person intends to engage in criminal or fraudulent conduct related to that proceeding, shall take reasonable remedial measures again, including disclosure to the tribunal. If necessary. So our first step isn't just blanket disclosure. We try and deal with our client first, and then if that doesn't work, disclosure. 3.3c says the duties stated in A and B continue to the conclusion of the proceeding. So if we know about it and we correct it, or we didn't know about it and we later find out about it, there's a duty to correct. Continue to the conclusion of the proceeding, and apply even if compliance requires disclosure of information protected by 1.6. So we see this whole thing on some level is an exception to Rule 1.6. I'll put exception to Rule 1.6 when necessary. And then letter D just says, in an ex parte proceeding, a lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision, whether or not the facts are adverse. So notice that's sort of a continuation of the duty to disclose adverse authority in a controlling jurisdiction. If you are in an in an ex parte proceeding with the judge, you are alone. And if the things that go against you, you have to disclose that to the judge as well. So all of these things are sort of our duty as officer of the court. Another thing that the book does is it points out some rules that we have been cross-referencing all along. Remember we did a case called Reese's Pieces. We talked about Rule 4.1 and how 1.6 may seem permissive, but if we are helping the client engage in fraudulent or criminal conduct, disclosure becomes mandatory. So if you look on the book on page 485, we have these rules that sort of overlap with each other. We have the rule of candor that we have been talking about, but we also have rules like 4.1, truthfulness in statements to others. So notice all of these are duties outside of the attorney-client relationship that may impact that representation. So we are officers of the court, cannot present perjured testimony. Notice the perjured testimony might even help the client, and the client may want you to do that, but we cannot do that because it's false testimony. So truthfulness in statements to others, and then you see the big 8.4, and all of you are familiar with this, misconduct. We cannot engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So notice that is a blanket prohibition that comes into everything, because notice in the box, in the discussion of Rule 8.4, that it applies to all conduct. So anything that we see that could be dishonest, that's 8.4. It's a catch-all, 8.4c, top of page 485. So 487, you see Nix versus Whiteside. It's a Sixth Amendment decision doesn't arise under the ethical rules, but it gives us this basic proposition. So if you have a criminal defendant and the criminal defendant says, I want to testify, we have to do it this way. The only way I can get off is if I offer perjured testimony. The attorney doesn't do that, and then the client on appeal says, well, that's ineffective assistance of counsel. We had an argument that we could make, and even though that argument sounds in perjury, the lawyer should have advanced that claim. Nix versus Whiteside said, whatever the scope of a constitutional right to testify, it's elementary that such a right does not extend to testifying falsely. So there's no breach of professional duty when the lawyer refuses to present perjured testimony. You see that on the bottom of page 487. So let's set up this next problem. This is 11-2, flight from Sudan, scene 1. So the first scene makes us sort of look at and evaluate our client's claim. And then following up on that, we probably won't get to the second one today. Following up on that is we accept our client's representations. We resolve them in favor of our client, which we can do, and we decide to move forward. But this first problem on page 489 is sort of a preliminary discussion. So this is Flight from Sudan, scene 1. And so we represent a political dissident, and we're trying to figure out whether or not that dissident will be deported. So we are a staff lawyer at the Immigrants' Rights Center. We represent Joseph Baragabi. He's an applicant for political asylum. You see on page 490, we're really concerned about his emotional state. And we think that things are so repressive in Sudan that if he was deported and he loses the appeal, he might commit suicide rather than return home. So there's a brutal dictatorship in Sudan that represses all political activism and speech. And Baragabi claims that he was a staff member and columnist for a newspaper called Democracy. So notice that this is going to be set up in a way that we have to corroborate what our client is telling us. It's going to give us some work on Rule 3.1. So 6 years ago in April, the government raided and closed the newspaper, arrested several of the editors. Baragabi escapes, he leaves with his family, comes to New York, but he gets to New York with a counterfeit passport. As soon as he gets to the United States, he tells authorities that he has this counterfeit passport, requests asylum, and as a result, he's automatically placed in deportation proceedings. So that's where we are. The standard, and remember I said you have to know what standard that we're trying to corroborate. The standard in a deportation hearing is a well-founded fear of political or religious persecution in his home country. So I can't go back there because if I do, I will be subject to jail or even worse because of my political or religious beliefs. So if our client is unable to meet the standard of well-founded fear of political and religious persecution, our client will be deported. So it's important for us to corroborate our client's story. Not a great success record in these proceedings. Only about 1/3 of asylum applicants are successful. And so notice this is the key. On page 490, only about 1/3 of asylum applicants are successful. A major barrier to victory is corroborating evidence. So we need either documents or testimony for other witnesses to substantiate our client Baragabi's story. So it's really easy to corroborate the context. We know what's going on in the Sudan. We know about this newspaper. But what is missing, you see this on page 491, is we cannot document whether or not our client has actually worked for this newspaper. Did Beragabi ever work for this newspaper? So we want to prepare a detailed affidavit, a sworn statement that our client will sign and file in court, telling the whole story. Under court rules, this affidavit is due in our next class, Thursday. So in a hearing in 2 weeks, we're expected to testify consistently with this affidavit, and we have been searching for corroboration of his employment with the newspaper. We can't find any of the editors or people who work in the newsroom. We get a lucky break, and we find the editor of the newspaper, Democracy, Mr. El Parra, but he does not recall our client. We're really surprised about that. He says, I never heard of Beragabi. I know everyone who works here. We describe our client's appearance, and Mr. El Parra insists that he knows all of the employees, and Mr. Beragabi is not one of them. So we have a series of questions. Should we tell Beragabi about our conversation with El Parra? Should we file the affidavit? Should we ask the court for permission to withdraw from representing Beragabi? We have to make a decision. Is it too early to do that? Did we violate Rule 1.6 by contacting El Parra? And then finally, did we do our job too well by finding out all of this information? So we're going to pick up with those 5 questions when we come back on Thursday. I finished your essay assignment. No major problem. Everybody got the 25 points. This was based upon an actual case from 2017. And all of you talked about diligence and competence. That was good. Failure to consult. That was good. Did not keep the client reasonably informed. That was good. More emphasis on not protecting the client's interests upon termination of the representation. A lot of you looked at that as 1.5. That wasn't bad in terms of fees and everything, but the money had already been spent. It wasn't a contingent fee. It was a fixed fee. And then the question is, for this unearned fee, the attorney protect the interests of the client, and he clearly didn't. More discussion about misrepresentation taken on behalf of the client. A lot of you sort of mentioned that he altered the date, but that's fraud. That's the type of misconduct that we talked about, and that impacted the representation. And then a little bit more discussion of malpractice. All of you sort of talked about the violations, but all of these violations lead up to some consequence. Some of you just said discipline could be done for malpractice, but it helps to go through the elements. So if this was an essay question, make sure you go through the elements. Duty, breach, and the breach cause of harm. Some of you mentioned the case within the case. In the actual case of this, the attorney was suspended for 181 days because of these mistakes. So they're up here, they're in alphabetical order. Just get your paper, no big deal. Everybody got the same thing. If you want to talk about it,